system, I can tell you there will be no society at all. Let us make no mistake about that. No matter how you lampoon the judiciary, no matter how you abuse judges, sitting or retired, no matter how you abuse lawyers, legal practitioners, the truth is that without the judiciary, without the legal profession, there can be no society. We may as well go back quietly, regress into history, into the Hobbesian state of nature, where life was short, solitary, nasty, and brutish. So it is the cause that hold the balance of scales between feuding parties. Otherwise, we may also end up carrying cutlasses. So the role of the court, therefore, is very sacred. Judges are God's representatives here on earth because society has decided to make them so. And you can imagine a human being having the capacity and being in a position of authority to sentence a fellow human being to death. That means such a function is not only sacred, it is also one that should be handled in a godly manner. And that is why, even as I defend the judiciary every day, I've done that for 43 years as a lawyer. Judges themselves, the judiciary itself, must rescue itself from itself, so that perception, which is normally reality, does not really hold sway for the judiciary. And that means judges must eschew corruption in whatever form, by whatever name, however beautifully dressed in royal garments. They must, so that when people like me are defending them, we'll be on very sure-footed ground that we can speak. That was why last year I wrote an article that was widely published critiquing judges and judgments, the dividing line. There's a difference between criticizing a court over a judgment delivered and going for the jugular of the judge or the judex in his personal capacity. A man or a woman who cannot defend himself. And that is why I have said in some presentations that I think the time has come when the judges should also form the National Association of Serving Judges. Then they appoint one of them as a public relations officer, PRO. Let him for that period not be sitting, so that you can also defend yourselves, because the right of reply has been given to us, and it's right from the Garden of Eden. We saw it applying in the principle of odi alteram partem, when God decided to give Adam and Eve a fair hearing in the Garden of Eden. Even though being omniscient and omnipotent, he had already seen the sins they were committing. So that is why in one case, in one, the Justice Wyford's lecture, and in another case quoted by Justice Uwais, revered former CJN, it was said that a corrupt judge is more harmful to society than a man who runs amok with a dagger in a crowded street. The latter, that is the man who runs amok in a crowded street, can be restrained physically, but the corrupt judge deliberately destroys the moral foundation of society and causes incalculable distress to individuals through abusing his office, whilst him being referred to as an honorable. Judges must always bear this in mind when they are deciding the cases. And that is why that woman, blindfolded woman, who did this case of justice, cannot see. And I want to add that she's also deaf. She's blind, she cannot see. She's deaf, she cannot hear. She's also dumb, she cannot speak. In fact, she is numb, she cannot feel. And that is what justice should be. So in Nigeria, under the Constitution, the power to hear and determine cases and enter judgment in favor of a party to a matter who has succeeded in proving his case lies with the judiciary, with the course of law. So judgment, I have 20 minutes. Thank you, sir. So judgments must be enforced, otherwise the party cannot use it for anything, and it may become a pirate judgment. There's no doubt that the age-long law is that a judgment of a court subsists until it is set aside on appeal by a higher court, and that means it must be obeyed. So parties or government agencies cannot choose and pick and choose which judgment to obey and which not to obey. The day we descend to that arena, then we are in trouble. So judgments are sacred, and that is why judges, in delivering them, should also hold their duties as sacred. In reviewing the role of the courts in the enforcement of judgments in Nigeria, it is also important to know the types of judgments that we are talking about. But first, let us start from brass tacks. What is a court? It is constituted and established usually by the constitution of a country through the government as an adjudicating body or institution with authority to decide legal disputes between and amongst disputants, and running and managing the processes of justice in criminal and in civil courts, and adhering to the rule of law, equity, and natural justice. There are various types of courts established under the 1999 Constitution. They are in charge of interpreting the laws, protecting rights of citizens, resolving disputes between citizens and governments, between governments interself, adjudicating on matters, guarding the Constitution, ensuring access to justice, upholding the rule of law, respecting the fundamental human rights of citizens, delivering effective remedies, and such other functions as may be imposed by law, statutory, or constitutional. Then the next question I interrogate: what is judgment? Saraki and Kotoye, that's causa celebre, defines it as a binding, authentic, official judicial determination of a court in respect of the claims and in an action before it. A person for whom judgment is entered in his favor is called the judgment creditor, while the judgment debtor is a person that is to pay for that judgment. We also have different types of judgments, which I know my lords here and my colleagues here know better than me. But for the purpose of this lecture, we shall still quickly run through them. Declaratory judgments: a ruling or judgment that defines or clarifies the rights of the parties involved in a legal dispute. It's a binding decision that can be used to resolve disputes, but it does not require the court to order any action to be taken. It merely declares or proclaims the rights of the parties, but it does not contain any order which may be enforced against the judgment debtor. We have executory judgments. Because every successful litigant desires to enjoy the fruits of his labor, an executory judgment is enforceable immediately after it has been given. And in enforcing judgment, I have here Toko and Government of Gongola State defining it as the process whereby a judgment or order of court is enforced or given effect to according to law. So the execution of judgment therefore encompasses the enforcement of the various writs provided for under the laws for giving effect to a judgment. It is one thing to argue your case before a court successfully and get judgment. It is, however, another thing for the judgment creditor to objectify the fruits of his neighbor as contained in the judgment. Otherwise, the winning party will end up with a barren judgment, a barren victory, a barren trophy. We have money judgments. We have modalities in money judgments for modalities for enforcement of monetary judgments. This process is adopted by a judgment creditor in a court to levy execution against the property of the judgment debtor, whether movable or immovable. It should be noted that property must be within the jurisdiction of the court. Otherwise, the judgment will not be enforced there. Under the enforcement of judgment rules, it can only be issued at the expiration for monetary judgment 3 days from the date of delivery, and such judgments are the judgment creditor property can be sold after the expiration of 5 clear days. We have garnishing proceedings when the judgment debtor has money due to him in possession of another person, such as a bank or other financial institution. Under this procedure, the court will order that third party or the financial institution, that is the garnishee, based on an application filed by the judgment creditor or his counsel, to pay the judgment debtor's money in their possession to the court. The court, upon receipt of the money from the third party, shall subsequently pay it to the judgment creditor as settlement of the judgment debt. We have judgment summons. Under the judgment summons, the judgment creditor initiates the process to court for the issuance of a judgment summons and advises the debtor to court to answer or note questions regarding its means. Pursuant to Section 63 of the Sheriff and Civil Processes Act, the outcome of the invitation are: 1. The judgment debtor may be committed to prison for failure to settle the debt when it is on record that he has refused to pay the monetary value. 2. The court may give an order attaching his property for sale. 3. The court may give an order for payment in installments. And 4. The court may give an order for the discharge of judgment debtor from prison. Small water. Water. I can't have 6 more. You just told me I should have 10 minutes now. We have sequestration, which is a process initiated at a high court, which is also similar to a writ of fieri fisher. Then we have judgment for possession. Under it, you have writ of possession, applies to cases of recovery of premises. Then you have warrant of possession. Then you have commuter order. Another head is judgment for the delivery of goods. This is where the judgment obtained is for the delivery of goods for the judgment debtor to the judgment creditor. So in all this, the role of the court is critical in ensuring that legal judgments are upheld and that parties comply with court judgments, orders, rulings, and decisions. And the courts of law have several roles to play in this enforcement process. There are judgment enforcement mechanisms by which courts provide various mechanisms to enforce judgments, including writs of execution, garnishment, and attachments. And these tools allow the winning party to collect what is owed to them. Hearing of enforcement actions, motions, and applications related to enforcement of judgments. You have contempt of court proceedings. If a party refuses to comply with a court order, the court may hold them in contempt. Courts have judicial oversight to ensure and oversee the enforcement process, that it complies with the law and that they are legal. We have the ADR, which courts use to allow for mediation and negotiation to resolve enforcement of disputes. We have appeals and judicial review. We have equitable reliefs, which a party may also take through issuance of injunctions and such ancillary reliefs. We have support for creditor rights. We have public policy considerations. Then we have the issuance of summons. So in all this, the role of the courts is one and the same as the role of the courts in obtaining the judgment itself in the first instance. All the procedures for the enforcement and execution of judgments, whether monetary, possessory, or recovery of land or premises, as I explained above, are true powers vested in the courts by the Constitution and statutes and rules. We should also note that the court will not just on its own perform or carry out this enforcement. It has to be at the instance of a party concerned. Otherwise, everybody will shout that the Judas has descended into the arena of the conflict, thus having his vision be clouded by the dust of the conflict. It is only when the court is satisfied with the submission put forward by the judgment creditor to demonstrate its entitlement to it that it will act. It is the duty of the enforcing court to also enforce the terms of the judgment strictly and not go outside them. The courts are also empowered under the Constitution of the Federal Republic of Nigeria 1999 and under the various court rules to entertain applications filed by judgment creditors as well as the judgment debtors. So in concluding, I want to emphasize that the role of the court in determining application brought before it by judgment creditors for enforcement of judgment is a very critical one, as it ensures that judgments are not barren. I also want to seize the opportunity to appeal to fellow colleagues, lawyers, that when we blame the courts, the judges, for corruption or alleged corruption, we must note that it takes two to tango. Without an offerer, there cannot be an offeree. Without a giver, there cannot be a taker. And the lawyer who has taken the oath of office must know that it is dirty and extremely objectionable to go and meet a judge behind closed curtains to say, "Can you help me?" If you need a help, go and argue it frontally, publicly, in front of a court. I thank God that I practiced law for 43 years. No judge in the country, serving or retired, even those dead, can say I've ever met them in chambers to help me in a matter. Nor have I ever written a personal petition against a judge. Rather, when my clients write petitions, I disown them and I get out of the case, because I do not want anything to soil my name. If you are dissatisfied with a judgment, for God's sake, there are appellate procedures. Appeal the judgment. That is why under section 6 of the Constitution, you have all the superior courts listed therein. High Court, Federal High Court, Court of Appeal, Supreme Court. If one head was bad at the High Court or Federal High Court, then go to 3 better heads at the Court of Appeal. And if it's a ponderous constitutional matter, 5 better heads. If those 3 better heads or 5 better heads are bad and you are dissatisfied, then go to 5 best heads at the apex court. And when it's a constitutional court, 7 best heads. If you are still dissatisfied, then go to your church or mosque and kneel down and pray to God so that you can have salvation in the hereafter. Not writing petitions to scurrilize names of judges who also have wives and husbands, they have children, they have relations, for God's sake. One other area I want to quickly touch as I go to see Mr. Attorney General, sir. I thank you, sir. I'm my Chief Judge, sir, and my CJN, sir. Is the practice where elevated judges, God bless them, I always pray for their elevation. Begin to have big parties thrown for them, inviting politically exposed persons to come and enjoy with them. Some of the people may have appeared before them. I've seen some parties where I know that some people, politically exposed people who attended the parties in their states, had matters before such judges. And one of them whispered to me and said, can you see that man decided a case for the state of that politically exposed person? And I didn't know. It is not good for our image. By all means, celebrate. We're not saying you should not celebrate. It's better to celebrate with your colleagues, lawyers, and judges like you. If the PEP people want to help, they can help quietly on the ground. Maybe words of encouragement, maybe buy you some books. Even if he has to give you money, it is not bribe, because he's just gifting you for exiting the lower court and going to a higher one. But not to be seen taking pictures publicly with such people, I don't think it is good. Then a final word. Courts, I beg of you, in the name of God, I genuflect. And watch me, my Lord, sir, I'm actually genuflecting. Allow lawyers to argue their cases. Don't shut them out and impose humongous costs because they have refused to withdraw their cases and they have insisted on arguing such cases. It is their right. I lost 1 year in the University of Ife to read law. I lost 1 year because I was reading English. And one of the reasons was the beauty of law. When I saw lawyers arguing in cause of law, rules of court have already dealt enough with us by saying you should just make written address and written briefs, not more than so number of pages. I agree with such rules to facilitate justice. And you now go to court, they just say adopt. You say, my Lord, I just want to emphasize. You say, no, everything you have written is on paper, adopt. Whereas the judge is not a machine, he's not a robot. He needs to be helped. And we lawyers are the ministers in the temple of justice, wherein is the prime minister. Allow a lawyer to draw your attention to salient points that he wants you to see, to address your learned mind to. You may limit him and say, don't take more than 2 or 3 minutes. Don't take more than 5 minutes. But don't just say adopt and go. That is also not good for the legal profession. Please, sirs, help me relay the word. Tell them not to award costs against lawyers in their person. You can award costs against the parties. How do you award costs against a lawyer for refusing to withdraw a case that he has filed after thorough research, which he believes to be right? It is not a good practice at all. And the judiciary itself can help itself from itself by delivering judgments, not just judgments according to law, but judgments according to justice. Judgments that deliver justice. Not judgment based on technicalities. Could the Supreme Court lapund in the case of Bello, an Attorney General of Oyo State, 1986, one Nigeria Weekly Law Report. Look at the merits of a case. What is the complaint? Don't say, oh, because you did not file this in time, then you shut him out. How has that solved the problem? How? I've not seen the new rules, but I was alarmed by some of the few points I saw in the new rules. I want to believe it cannot be true. My Lord, sir, the new Federal High Court rules that there will be no amendment allowed at a certain stage after a matter, that no amendment can be allowed. I do not know, I have not seen the rules, but I just want to believe that it's not true. Because to say no amendment is to say that we can no longer make mistakes as mortals. And such a rule will be overriding or overruling all Supreme Court decisions to the effect that amendments can be carried out anytime before judgment. I wish the judiciary good luck. I wish the legal profession good luck, because without the legal profession, without the judiciary, there can be no country. And I still want to make this point finally, that the judiciary, in spite of all the problems we are talking about, still remains the best arm of the 3 arms of government. The judiciary, the executive, and the legislature, under a doctrine of separation of powers, ably propounded by Baron de Montesquieu.
You've listened to that? You hear by yourself. That is it. Even Dele Farotimi said before, he doesn't want anybody to plead on his behalf. Let them take him to court. He will defend himself. He has all the evidences. But Nigeria do not want to charge him to court for him to come and defend himself. Can you imagine? They are giving him all the conditions to accept all the conditions in the prison. Somebody who is already in the prison, you are giving him condition to accept this by all means before he can be released. That's what he said. This is what this man is saying now. There's a lot of corruption. Everything is going on in this. I don't know. I'm not surprised. You can see what is going on in our country today. They don't allow the rule of laws to prevail again. It becomes somebody is dictating for the court, for the rule of law, for the courts to do, dictating for them to do. This is what I want you to do to this person. You don't allow the rule of law, to go through the normal process of defamation. Everything, just everything, corruption everywhere. And this is the reason why we're talking about corruption. So this one has exposed a lot of corrupt people, a lot of corruptions in our judiciary today. Anyways, you hear for yourself. Please do me a favor. Subscribe to this YouTube channel. I'll be your guy. Run out for me now. Please subscribe.